So, Your Honor, I believe the issue arising is the question as to why the EACC has not signed the plea agreement that has been filed in court. Just to give a genesis of this matter, you granted parties leave on application by the counsels for the accused persons to proceed and engage in plea negotiations. We attended various meetings conducting the said negotiations, and the last meeting was held on 28th of August.
Slower. August this year.
Yes, sir. That is last week on Thursday. During the said meeting, several issues arose in that there was an indication that there was a plea agreement that was to be entered into, that was to be signed, Now, as representatives for the EACC, we requested for the draft plea agreement as the practice has been that once negotiations take place, a draft agreement is shared between the two institutions, the EACC and the ODPP, where we subsequently seek instructions on the draft agreement. Now we requested for the agreement, the draft agreement, but the same was not availed to us. It was actually objected to by the counsels who are there for the accused persons and also the prosecution. We were not able to even gain sight of the said plea agreement to know the contents. And the next time we got to know about the plea agreement is when we came before you, when my colleague came before you on first, when it was indicated that the plea agreement is already on record. Your Honor, in view of the circumstances, we have not been able to peruse the plea agreement. We have not been able to seek instructions on the same. I believe, Your Honor, I have covered the issue that you had raised. But we are still amenable to have the said plea agreement shared with us so that we can seek instructions on the same.
Come again?
I'm saying we are amenable to having, subject to your directions, having the said agreement given to the EACC so that we can seek instructions on the same. That's all you want.
Very well, thank you. The questions I had have been covered. Thank you. Next is the prosecution, Ms. Nora.
Good morning, Your Honor.
Good morning.
I will do a very brief response on the issues raised by EACC. When we first came to this court and informed the court that we had received a request from the accused person's counsel, that what they had requested from us was that we engage in alternative dispute resolution mechanisms with the aim of settling this matter out of court. And I remember.
Slow.
Sorry.
Yes. You can continue.
Yes, that when we came back before you, we informed you that we had agreed to settle the matter via plea bargaining.
By we, you mean?
Yes, the teams, the accused persons and the EACC, via their communication to the office of the DPP in a letter dated 19th of May 2025.
Well,
The request from the defense, let me just clarify, Your Honor.
Give me time.
Yes.
I wanted to put the we in context.
Yes, that is what I want to clarify. The request was
Yes.
for alternative dispute resolution mechanisms. We have quite a number.
Yes.
So the one that we settled on as a team, that is the defense team, representing the accused persons, and EACC via their letter to the Director of Public Prosecutions, dated 19th of May 2025, was that they were amenable to the matter being resolved through the bargaining. So we started the process by communicating to the accused persons through their counsel and to EACC, inviting them. First, the meetings were held between ourselves, EACC, and counsel representing the accused persons.
That was on?
We have attached the various attendance sheets, Your Honor. We had a meeting on 22nd of April 2025, 27th of June 2025.
A minute. Come again, fast.
The first meeting was on 22nd of April 2025, Your Honor.
April 2025.
27th of June 2025. 25th of July 2025. The last meeting that was alluded to, where the agreement was discussed, was held on 28th of August 2025. During these meetings, issues to do with the case was discussed, the settlement agreement, the consent order, and the payment.
Oh, slower. It's soft on me.
Sorry, Your Honor.
Today the machine is not running.
Sorry.
So that is why I'm keen to capture each word proceeding through your lips. Were discussed.
Yes.
There are details.
Yes, the details, we have
Sorry.
attached all that in the plea agreement.
Just come again on that statement.
Yes, the issues to do with this matter were discussed, the genesis of the agreement between EACC and the accused persons in the civil suits. And Your Honor, even during the meetings, we made parties aware. I remember during the last meeting, minutes are available. We informed the team, or rather the teams, that what we had agreed on was what we had indicated in the plea agreement. So we had discussions with all the teams. And on 28th of August, when we had the plea agreement, we requested the team from EACC, we informed them rather of the contents of that plea agreement, and they indicated to us that they had no instructions. This is after 3 meetings.
Slow. You forget quickly.
Sorry.
Watch the pen. That was the rule, the old rule. It works still. Senior counsel can confirm that. They had no instructions.
Yes.
Continue.
We want the court to know that this was after we had discussed with them in our meeting on 27th of July 2025 and informed them that we intended to avail the plea agreement in our next meeting. Our assumption was
Continue.
That because they had been attending all the meetings as scheduled, then what was being discussed in the meetings was then being reported back to the office.
By office, you mean?
I mean, they were coming there as representatives of EACC. We were sitting
So
there as
by
representatives.
office, you mean to
Yes.
EACC?
Yes, yeah. So it was clear, even in our letter inviting them for the meeting on 28th of August, 2025, that the intention was then to sign the plea agreement. You know, after they informed us that they had no instructions, and as prescribed by section 137, the prosecution went ahead.
137?
Yes. On plea bargaining, on who should sign the plea agreement. So we went ahead to sign the plea agreement with the accused persons, considering that this was happening on the 28th of August 2025.
Considering, sorry?
That this was happening, this agreement signing took place on the 28th of August, and the matter was scheduled for hearing on 1st of September. So, you know, we did not refuse to hand over any agreement.
Slow. I'm behind you. We did not
refuse to hand over any agreement. Parties had been attending these meetings. They were aware that that was the day we were going to sign the agreement. I have deliberately left out the issues to do with the settlement in the civil suit. I will leave that to the defense team. So looking at the loan plea bargaining, Your Honor, it is our take that we complied with the law. We have attached copies of attendance sheets. We informed the EACC of the request from the defense. As indicated, they communicated via the letter stating that they were amenable to this matter being resolved through plea bargaining. That is all for now on our part.
Thank you. I will now hear from the accused persons. And of course, I'll begin with the first accused, Mr. Kilokumi.
Thank you, Your Honor. Your Honor, the EACC is not a party to the bargaining agreement. The EACC is attempting to usurp the powers vested in the office of the Director of Public Prosecutions. Your Honor, Article 157 of the Constitution vests prosecutorial power, including the power to withdraw criminal charge in the office of the DPP. EACC does not feature at all in Article 157. In matters to deal with withdrawal of a charge, only 3 parties feature under the Constitution: the accused person, the office of the DPP, and the trial court. Those are the only recognized parties by the Constitution.
If you can be slow on me.
Yes, I'm sorry, Your Honor. I will watch the pen.
And I know you don't come from the rift. I wonder where you're getting that speed. Recognized parties.
And Your Honor, I wish to draw your attention to a provision that is very well known to you. That the office of the DPP, in exercise of its prosecutorial power, is not subject to the directions or control of any other authority or agency. In this particular case, Your Honor, EACC is intermeddling with the constitutional power vested in the DPP. They are trying to exercise control. They are trying to direct. Sorry, Your Honor.
Control. The last there.
Yes, they are trying to control.
Yes,
they are trying to direct. The office of the DPP contrary to the Constitution of Kenya. And that cannot be permitted. And Your Honor, we must put things into context. EACC is acting as a complete pretender in these proceedings. EACC and the charge sheet will confirm they were the complainants for the case to be instituted, for the criminal case to be instituted. After invoking the criminal justice system, they went to the civil courts. And there they filed suit number 32 of 2018 and suit number E10 of 2021. Your Honor, the claims in the civil suit, the claims in this criminal court are exactly the same. EACC was claiming for 73,474,376 and 90 cents.
Come again, 73 million.
73,474,376 and 90 cents. That is what they claimed in the civil suits, and that is what is reflected in the charge sheets. This same EACC entered into negotiations with the accused persons. I personally attended those negotiations. And the starting point of those negotiations were that the criminal case will be withdrawn and the accused persons will make a settlement in the civil courts. And indeed, Your Honor, on the 4th of June 2020, sorry, Your Honor.
Indeed,
Your Honor, a settlement agreement
that
was signed on the 4th of June 2024 and filed in the two civil cases. In that agreement, Your Honor, the accused persons surrendered to EACC immovable properties valued at Kenya shillings 235 million.
Come again.
In those settlement agreements, yes, the accused person surrendered properties, immovable properties, worth 235,600,000. Your Honor, you will note that is triple the amount EACC was claiming. And why is it triple? It is triple, Your Honor, because it was assumed if the court were to convict the accused may be ordered to pay double of the sum that was in question, in accordance with the Anti-Corruption and Economic Crimes Act. And Your Honor, to use street language, EACC were completely sorted. And for them to turn around and try to depict the office of the DPP as if it is doing something wrong is a public relations gimmick of trying to take a higher moral ground without any justification whatsoever. More importantly, Your Honor, we need to ask the legal question whether the EACC is a party to the plea agreement and whether it is required in law to sign that agreement. And the answer is no. EACC was invited to the plea negotiations out of sheer courtesy, out of civility, out of good manners. There was
slower.
Sorry, Your Honor.
Pause after every.
I would watch the pen.
Yes. Out of courtesy,
Yes, civility
civility,
and good manners.
and good manners.
There was no legal obligation whatsoever to have EACC in those negotiations. Next time they should be kicked out.
I'm not sure I want to record that one. That one coming from senior counsel is heavy.
That's fine. That's fine, Your Honor. Let me justify the statement that I've placed on record. And I am justifying it under section 137A of the Criminal Procedure Code. That section identifies only two parties to a plea agreement. And Your Honor, I want to make it very clear that plea agreements take different shades. This plea agreement is for the charges to be withdrawn under section 87A. Your Honor, with your permission, I will just read what this section says, subject to section
That is one.
137A.
Thank you. I'm
Yes.
aware of their content.
You're aware of the content. But the point I just want to make is only two parties are identified, the prosecutor and the accused person. And then 1B says the plea agreement could constitute withdrawal of the charges. Your Honor, I also wish to draw your attention to 137B. It identifies two parties, the prosecutor, the director of public prosecutions, and the accused. The complainant does not feature at all. Your Honor, I also draw your attention to 137E, paragraph D. It again identifies only two parties as the parties to the plea agreement. And then, Your Honor, we come to the important aspect where EACC could have a possibility of featuring and does not feature in this case. And that is 137E, subparagraph E. And Your Honor, this one is important. It says the plea agreement be signed by the complainant here is EACC, if a compensation order contemplated in section 175(2)(b has been included in the agreement. The agreement is before Your Honor. It has not included a compensation order under section 175(2)(b of the Criminal Procedure Code. And for that reason, EACC has nothing to sign. They are not required to sign any document. They are not required to sign the plea bargain agreement. Your Honor, apart from the Criminal Procedure Code, the substantive, we have the plea bargaining rules, and I wish to draw your attention to rule number 2, which identifies the parties to a plea agreement, and EACC does not feature. Rule 6 identifies again the parties to that agreement. EACC does not feature. In the rules, Your Honor, and this is important, Rule 14. Just for context, Your Honor, it's a short rule and an important one for the matter before you. The rule reads, a plea agreement shall be finalized when the prosecutor and the accused person sign the agreement. It's finalized. B, where applicable, the legal representative shall also sign the plea agreement. In this case, a legal representative is not featuring. We are all dealing with adults, there are no children in this matter. And then the most important one for you, Your Honor, 14 sub rule 3, where the plea agreement includes a compensation clause, the complainant shall sign the compensation clause of the agreement. The plea agreement is before Your Honor, and we challenge the EACC legal team to show us where there is a compensation clause. There is no compensation clause in the plea agreement. What is contained in the plea agreement is an acknowledgement that the accused persons surrendered properties, immovable properties, valued at 235,600,000.
Sorry?
What is before
A minute,
your
a minute,
honor, the
a
plea
minute.
agreement?
A minute.
Oh, sorry.
You can
Yes. So,
continue.
Your Honor, what is in the plea agreement before you is an acknowledgement that EACC has received 235,600,000 in surrendered immovable properties and 2 motor vehicles. The plea agreement itself does not have a compensation clause. For these reasons, Your Honor, we urge you to find and hold that EACC has no role to play whatsoever in this plea agreement. We also ask the court to hold and find EACC is not a signatory. There is no requirement for it to sign the plea agreement. That is all I wish to say, Your Honor. Thank you very much for listening to me.
Mr. Ochua.
Your Honor, for purposes of procedure, with your kind permission, we had agreed for purposes of this proceedings.
Sorry?
We had agreed with the counsel for the defense that senior counsel Mr. Kilukumi will speak first, and then Mr. Sagana will address the court, and then thereafter the other counsel will get another issue pending. Right. So we kindly request that Mr. Sagana to address you before the other counsel time, if you may permit.
That is in order.
Thank you very much.
Mr. Sagana.
Thank you, Your Honor. Your Honor, for the subsequent accused, we want to adapt fully the submissions very ably led by our senior colleague for the first accused person. And for good usage of time, I do not intend to rehash the submissions, save to add for just 4 key points. You know, in this matter, the complainant is EACC, and it is fully related to the 2 civil matters where EACC is the plaintiff. ADR in the 3 matters commenced between the accused person's hearing.
The 3 means
The 2 civil matters and this
one.
This one. The ADR in the 3 matters commenced between EACC and the accused person's hearing. Without getting into the content, the plea agreement before you has several attachments, including correspondence between my law firm representing all accused persons and EACC with reference to the 3 matters. The second point is that there was a full settlement by way of restitution and the settlement agreement adopted by the court in the 2 civil matters leading to the forfeiture of the 8 properties valued at 265 million and the 2 motor vehicles. Your Honor, it would be instructive to note that in this matter, a property in Laurentian is a subject and 2 motor vehicles. And the property and those 2 motor vehicles are part of it.
Too fast. Kindly take it slow.
And it is instructive to note that a property in Laurentian
I recorded that.
and
2 motor
vehicles
vehicles. Subjects.
form subject of this proceedings before you are part of the properties forfeited. It is only after the settlement between the accused persons and EACC that the accused persons sought to enter into an ADR with the DPP. And these negotiations, as you'll see when you get to the subject, are almost entirely based on the settlement and the restitution between the accused persons and the EACC. The meetings were held with the full participation of EACC. And just one notion I'd like to correct. In the second last meeting at the 25th of July of this year, The DPP did indicate to the parties its decision to prefer the option of withdrawal as a settlement in this matter. And on the final day, that's on the 28th of August, EACC, in a surprising time, did indicate at the meeting that they would not be signing that agreement. But we emphasize that very rightly so, as indeed they are not parties to that agreement. We urge that you make that determination in leaving it. In favor of the DPP and the accused persons, so as to proceed with the substance of it. That will be our mostly.
Wrong. Thank you, Mr. Ochua now.
Please.
Yes.
Your Honor, I wish to adopt the submission by Mr. Kilukumi and Mr. Sajana in their entirety. Same, just to add that EACC cannot probate and approbate at the same time. We are where we are because of the conduct of EACC. The governor of the genesis of the basis of the plea agreement placed before you arises out of a consent or an agreement that EACC had executed in the civil cases. It has been mentioned. That agreement, Your Honor, under the Act, EACC Act, Cap 65, that settlement forms part of their report of assets recovered. And that report annually is submitted to the people through Parliament for approval. In those two suits, civil suits.
Slower.
Sorry. In the two civil suits.
Slow.
Sorry.
Just hold your horses as I complete your previous statement. And in the two civil suits,
The office of the ODPP were not parties. So in reaching that settlement, it was at the sole discretion of EACC who were deemed to have acted in the best interest of Kenyans generally. So there's public interest covered in the civil suits. And as submitted, that report will be laid before Parliament for approval. And those are the representatives of the general public. So if we are to subject that settlement to the omnibus test, we are represented by the parliamentarians where the report will be presented. Now, when it comes to this criminal suit, what does the EACC, the Anti-Corruption and Economic Crime Cap 65 state in section 37, which deals with the annual report on prosecution? This is what is declared. 37 plus 1 declares the director.
37.
37 subsection 1.
If you can give a summary, please.
Yes, just to summarize.
Yes.
The Director of Public Prosecution shall prepare an annual report with respect to prosecution for corruption on economic crimes. This is just to lay the emphasis that the powers to prosecute in economic crime, as in this case, that consent to prosecute or withdraw rests with the office of the ODPP. And in executing the plea bargain agreement, they have done it within the powers, as we say under section 37(1) and the Constitution. Lastly, for purposes of your record, Your Honor, as officers of the court, we must be candid and honest. EACC, through its officers, has been participating in all meetings leading to the expiration of the plea agreement that has been filed. I think there's an element of dishonesty on their part to try and disclaim that they are not aware of the report. Your Honor, we were before.
Slower.
Sorry, all right. We were before you on Monday, which I believe was the first, when the report was filed. ODPP was present, and the officers from EACC were present. When the matter was adjourned, you are aware of the filing of the report. So even if we were to give them the benefit of doubt, they would have accessed the report which is available in the court file. You are aware of its filing. they participated in the proceedings on Monday. So, Your Honor, they cannot be heard to be saying today that they're not aware of the existence of that report. That is dishonest. And I submit that their application should be disregarded and we should proceed as submitted by my I agree that the proceedings on the plea agreement should proceed.
Mr. Owino.
Your Honor, what more can we add after the eloquent submission by senior counsel and my two seniors, Mr. Sagana and Mr. Ocho? Your Honor,
Oh, slower. Continue.
Your Honor, I come to the humble conclusion that there's nothing more to add to the submission. Your Honor, we will be seeking to adopt them as submitted. That is all.
Very well, thank you. Mr. Ario.
Your Honor, on behalf of the four accused persons, we wish, Your Honor, to adopt and associate ourselves wholly in the very able submissions. I am a senior fellow in Kumi, and my three colleagues who have spoken ahead of me. And Your Honor, as you proceed to look into this matter in the minute, it is our take also, Father, that indeed there is no application before you per se. In opposition to what we intended to achieve and adopt this morning. And I believe there is no impediment that is before this court at this juncture that will deny the parties an opportunity to reach their goal and intention to enter a plea bargain as earlier achieved, intended, and scheduled by the parties before this court this morning. I don't want to submit any further because I may run the risk of addressing issues that perhaps the moment of opportunity has not come. Once the document is properly kept before the court, we shall address you further if needed.
Thank you. Ms. Kahiti. If you can project
On behalf of
like me. Yes.
I fully concur with the submission of the amendment. And as Orino has said, I have nothing to
Thank you. To the last one, Mr. Musa.
Last but not least.
Yes, last one, but not least.
On behalf of my clients, I fully associate myself with the submissions of my seniors. And only wish to add the following. Your Honor, the preliminary issue raised by EACC is that they have not signed the agreement. Your Honor, they have not stated that they were not part of the meetings that led to that agreement. Your Honor, they have not stated that they did not take minutes of the sections of law that were discussed in that agreement.
Come again on that point.
Your Honor, they have not stated that they were not informed of the sections of the law that the prosecution wishes to rely on. In those meetings, in fact, if my memory serves me well, when we were initiating this process, EACC were given special leave to address the court as to whether they are amenable to the process of out-of-court settlement. The answer was they are amenable to the process as long as it is done under section 137 of the CPC. Your Honor, the last meeting that we had, the DPP was categorical and stated that the suit before court will be withdrawn under section 87A and 137A1B, section that EACC had requested. You know, when a learned counsel tells you that we are withdrawing under section 137 A1B, that section is a self-explanatory section. You don't need to see anything else. It's a total withdrawal. Same with section 87A. And as had been submitted by my seniors, that section, those sections that I've just stated, the parties, all participants are limited It's not everyone who is required to sign an agreement that arises out of those sections. So what's the contention of EACC now that it has been clearly established that there is no requirement in law that they sign an agreement arising from those sections? What's the contention? That's a pertinent question. Are they saying that there was no restitution? Are they saying that the restitution that occurred is not subject to this case? Are they saying that the properties that were surrendered are not subject to this case? Are they saying that the agreement that has been filed by the DPP is in violation of any laws with regards to public interest? I have not had such a submission being made. As such, I fully believe that the preliminary issue raised has no standing in law. Nothing prohibits this court from going ahead and delving into the content of the agreement and, God willing, adopting the same. That's all.
Thank you, Ms. Nganga. Any rejoinder?
There are a few issues that have arisen which are critical to be addressed, considering that we have not really addressed.
If you can project your voice.
So I'm saying, considering we have not submitted on the issue of the role of EACC in plea negotiations, we wish to submit on the same.
That is in order.
And I would wish to have the same addressed by my senior Mr. Gishangi.
Your Honor,
that is Mr. Gishangi.
Yes.
Mr. Gishangi. You can continue.
Yeah, allow me to start by responding to the DPP's.
If you can project kindly.
Allow me to start by responding to what the DPP has indicated to this court. Now, Your Honor, the practice of plea agreements is that once the parties have come up with a draft, the draft is shared with all the relevant parties. If there are amendments, if there's any editing, the same is done. Parties that need to seek directions or instructions from their principals do so. And once all issues are agreed upon, then the pre-agreement is signed. Your Honor, that is the practice that has been established And this practice is in line with section 137A to O. I'll be coming to that shortly.
With section
137A to O of the Criminal Procedure Code, as far as the plea agreements are concerned. Your Honor, if EACC's participation is not required in this process, then the slot for them to sign would not have been included in the pre-agreement. I'm sure they...
slower.
Sorry, Your Honor. I'm sure the pre-agreement filed in court, as indicated by my colleague, we have not seen it, but I'm sure it has a slot for EACC to sign. And that is what drew the attention of this court, because the court knows the practice. Your Honor, our issue is very simple. We be served with a pre-agreement or the pre-agreement is available to us. We seek instructions. If we are told to sign, we sign. And we have no issue with that. We just need the pre-agreement.
You're too fast.
Okay. Okay. Sorry, Your Honor.
Kindly watch the pen.
Okay, I will.
Yes.
I will.
So I stopped it. If we are asked to sign, we sign.
You all know what I'm saying is?
No, I'm just giving you direction where I am.
Yes.
So that you pick it from there.
Yeah.
Yes.
Once we receive instructions to sign, we will sign. And the instructions must come from our bosses. So we just need the pre-agreement. Now, Your Honor, in regard to the participation of EACC in a pre-agreement, I will invite this court to look at the relevant section, that is 137A to 137O of the Criminal Procedure Code. But allow me to draw the attention of this court to section 137D. Now, Your Honor, kindly allow me to
come again.
Allow me to draw the attention of this court to section 137D. D.
Yes.
D for dog. Allow me to just state that it provides that the prosecutor shall only enter into pre-agreement in accordance with section 137A, and it provides A indicates after consultation with a police officer, investigating the case. Now, the police officer investigating this case is EACC. Because the matter involves corruption and economic crime. Now, when we look at 137B, 137D Part B, it goes ahead to deal with some aspects. That must be put into consideration before a plea agreement is arrived at or is arrived on. For example, nature and circumstances relating to the offense. Another example is personal circumstances of the accused. And finally, interests of the community. EACC being the mandated, the constitutional institution that is mandated with the fight of corruption in this nation. Is in the best position to provide these three issues or these three considerations, these three aspects in the process of plea agreement. It is only the investigating officer who can be able to provide these aspects. In regard to C, I wish to state that to 137DC, I wish to state that EACC is here, ready and willing to play its part as far as this plea agreement is concerned. Your Honor, that scores the importance of participation of...
come again?
Your Honor, that scores the importance of the participation of EACC. Without this participation, the plea agreement does not meet the requirements of section 137 A to O. Your Honor, it is true that my senior Kirkumi has agreed that EACC is the complainant. If you look, as you retired, right, you are ruling on this issue. Kindly look at section 137E.
Section
137E of the civil criminal procedure code. Now, in regard to the civil matter, Your Honor, where a consent was entered, I wish to draw the attention of this court to section 193A of the Criminal Procedure Code. The civil matter has no bearing in this matter, in the criminal matter before you. If the defense wants to use the concept that was entered into, let them abuse it as evidence or even use it for mitigation if they will be convicted by this court.
Yes, Mr. Winner.
I didn't want to do this to my senior. But the EACC is delving into new issues, which are not
into
new issues. And are delving into the substructure of the country. Now, we may not have an opportunity to submit on those new issues. We do urge the EACC to stick to the rules of the job and not attempt to steal a market. It's still more.
in your
I stand
response.
guided. I stand guided because they say that is a settlement that has been done and it was quoted by all the councils. And I'm submitting in line with the settlement that they indicated to this court.
You may have your seat. Well, the court has considered the objection raised by learned counsel Mr. Wino. The response to that objection by learned counsel Mr. Gishangi. The court issues the following broad direction that in your submissions be guided, number one, by the specific issues which were raised by learned counsel watching brief for EACC. And number two, be further guided by the new issues raised by learned counsel representing the accused persons. Beyond that, including raising issues of mitigation and evidence in trial, those are completely outside the circle of the issues before us. Continue, Mr. Gishangi.
Guided, well guided, Your Honor. It was indicated that one of the conditions in the civil negotiations was that the criminal matter would be withdrawn. Your Honor, I'm inviting you to look at the settlement. That was done in the civil matter. And you arrive at a finding that no
the
such
settlement is dated, give particulars.
the settlement arrived in the civil matter.
Give particulars.
It's 4th June 2024.
Yes. Yeah, 4th June 2024.
4th June.
2024. And I believe it is on record.
Under which matter?
The parties are...
Citation. Citation. Sorry? Sorry? Mr. Gishangi?
Yes.
This High Court?
Yes, it was in the High Court. Yeah. EACC case number 32 of 2018.
So EACC
32 of 2018.
At which court?
The High Court. The Anti-Corruption Division.
Anti-Corruption Division.
Yes. Then we have 10 of 2021.
Bro, you can continue. That is all I needed to add.
Fine.
Continue.
Your Honor, you'll see that no such condition was introduced. That is the condition to withdraw the criminal matter. Your Honor, if the DPP wants to withdraw this matter under Section 87A, as a practice, or as the practice is, Let them make a formal application in court. And they will be responded to.
Continue.
If the DPP wants to withdraw this matter under section 137, then as indicated, the pre-agreement has to go through the process, or it must be in line with the provisions of the law. In regard to the rules 2614 of the pre-agreement, those rules are subject to criminal procedure code. Your Honor, finally, let me indicate to this court that any corruption matter or any pre-agreement that is dealing with the corruption matter, and corruption issues are issues of public interest, as it were, in this nation today. It will not be correct for anyone to say or to indicate to this court that the body that has been mandated by the Constitution to fight corruption has no role in such a pre-agreement. Thank you, Your Honor.
Sri, come in front.
Thank you, sir. Thank you. Thank you, Council. Thank you, Senior.
No.
Okay. I'm a blood.
Yes. Yes, your name is?
My name is Jeffrey Onyango Otieno.
Jeffrey
Onyango Otieno. I'm shy. Yeah.
Yes.
Jeffrey Onyango Otieno.
Yes.
I read about this matter in a local print a couple of days ago,
Yes.
and I've been following up about this case. And a few days ago, I approached the registrar. They told me the matter's already been settled.
The what?
The matter's already been settled. And later to come to find out it has not. So he advised me I need to write to you or to both courts, because the subject is facing two cases. My apologies for calling the subject, but it depends on how counsel applies.
Yeah.
So the subject, Mr. Obado, has two cases pending. Yeah, okay.
Kindly allow me to talk also.
No, we'll tell you well.
When people are in post, this guy had about it from some new politician
There's nothing wrong about that.
A minute.
They know.
Okay, I'm sorry.
They are crucifying you for nothing.
A minute, Mr.
This guy has come here.
Mr. Obado, a minute.
Your Honor, this one, I also have my right.
Yes.
This fake guy can't come here to start tarnishing my name. No,
Very well.
that they crucified me for something that I should not have been charged for.
Very well, Mr.
It's a guy
Obado.
I've never seen in Migori.
Thank you. Mr. Obado, have your seat. Remind me your name.
My name is Jeffrey Onyango.
What is your point?
My point is,
in one sentence.
mine is easy. I want to file an application, an objection based on all interface. Everybody has spoken.
Or you want to file an objection?
Yeah, based on the.
Very well. Thank you.
That's all I want to do.
Thank you.
Based on quantum and time.
Thank you.
I'm sorry.
Before going, I've not given directions on you.
Okay, I'm sorry. I've heard about it.
Yes,
And I've seen your tape.
So you want to file an objection?
Yeah.
In your capacity
as a citizen of the Republic.
Citizen.
As humanity, because
very well. Answer my question in one word.
Okay.
In your capacity as what?
As a citizen of.
Full stop.
Okay.
No further.
Okay, thank you. And thank you for allowing me.
No. Before you leave.
Okay.
So anybody is at liberty to do whatever they wish.
Okay.
So long as it is within their rights and power.
Okay.
And you'll get further advice from the registry on how to proceed in that respect. Sawa. Once, in the event it lands before me, I will proceed as the law directs me. Sawa.
God bless.
Thank you. Have a seat. Have a seat. Thank you.
No process. It's a process. It's all right.
Very well. This court will take a break for 20 minutes to craft some guidelines and directions on the way forward. We therefore resume sittings at 12:20 for the directions. Thank you, and I think unless you need a longer period, from 20 minutes.